Thank you for that. Well, it's not all you have because we're going to move on to our
Yeah.
next topic of discussion, which is the MS4 lawsuit. So, Ms. Dice, can you give just a background for the viewers watching on what exactly this MS4 lawsuit is about and how it came about?
Sure. So MS4 fees are fees that are generated as a result of what's called an NPDES permit. That permit is issued to a municipality to collect and manage stormwater. Monroeville developed an ordinance and enacted it on October 9th, 2018. And a part of that ordinance, it was called the Pollution Control and Flood Reduction Fee Ordinance. And what it did was it was enacted to collect fees to defray the cost to operate, maintain, repair, replace, or improve the stormwater system in Monroeville. And because it was adopted in October of 2018, the effective date became January 1st of 19. And if you are a property owner within the municipality, depending on the amount of impervious surface, so surface that has some type of pavement or some construction on it, they devised a calculation for a fee for each property owner to pay to the municipality to upgrade and improve the stormwater sewer system. And in fact, I'm going to read a provision in the ordinance. It says that the imposition of rental rates and charges, it's section 3 of the ordinance, states it's for the use of, benefit by, and the services rendered by Monroeville storm sewer system, including operation, maintenance, repair, replacement, and improvement of said system, and all other expenses, rental rates, and charges are hereby imposed upon each and every property that is connected with and uses and is serviced by or is benefited by the Monroeville storm sewer system, either directly or indirectly, upon the owners of such properties. Such rental rates and charges are imposed January of each year, which means that you have a fee every year. All residents here who own property also had to pay these fees, and you probably paid them since 2019. Gateway in 2019 had 11 properties. I believe the properties have not changed to still have 11 properties. But the fee amounts to, for Gateway, is $90,228.60. So when this ordinance came down, we looked at it along with actually other school districts because they were also interested in this litigation. And looking at the school code, it's our legal opinion that the school would be exempt from these fees because section 776 of the school code says that we are exempt from every kind of state, county, city, borough, or other tax, as well as from all costs or expenses for paving, curbing, sidewalks, sewers, or other municipal improvements. So it was our legal opinion that the district would be exempt from these taxes. When I learned from Paul Schott that these fees were paid, we proceeded to appeal the process. And under the ordinance, it requires you to appeal to the municipal manager first. So first we got our notices, I believe it was in December of 2018. Gateway paid their fees January of 2019. Properties. We get the denial back from the municipal manager on March 13th, at which time I contact the municipal solicitor and we have a discussion because in court, if you want to appeal a decision from a manager, in this arena, you would normally file what's called a statutory appeal. It's administrative appeal, and you go down one route in the court system. After speaking with a municipal solicitor, we both agreed, because we're challenging the validity of the ordinance and not challenging how you calculate the fee. We don't dispute how they calculate it, but we're challenging the validity of, does it apply to us? We agreed to waive all time refrains in having to file that statutory appeal. It's a waste of time, money, and energy for all parties. So on April 2nd, we filed what's called a declaratory judgment action. A declaratory judgment is a case, it's a complaint that you file in the Court of Common Pleas. It is essentially asking the court to declare whatever the contractual, or in this instance, the ordinance, is applicable or not applicable to the school district. And so once the court makes a determination, it becomes binding, even if the ordinance is still written the way it is. If the court would come down and say it's not, we're exempt, then we're exempt regardless of whether or not the ordinance is written improperly. As a result of gateway filing, there were other school districts that also filed a similar action. Because there are more than one school district actually in the jurisdictional limits of Monroeville, Forbes Road, as well as the AIU Sunrise School. And so both of those entities are affected by the exact same ordinance with respect to this litigation. On April 25th of 2019, another school district also asked to be a part of this. It was Cornell School District. And the courts eventually on August 14th, 2019, granted that that Cornell School District would be part of this litigation. The same thing happened with West Allegheny School District, although we just got the order August 10th that they are part of this litigation. Procedurally, the next step was on December 31st, 2019. Monroeville finally answered our complaint. We were going back and forth with how are we doing this. All the solicitors were trying to figure out what's the best way to move this case forward.
So can I interrupt?
Sure.
It sounds like you were working with the municipality about this. You
Oh,
were
absolutely.
attempting to settle this. You were attempting to work, not settle, but you were attempting to work out the details, and you were in communication with them throughout this process.
Yes, and this Monroeville and I worked very well on this and very accommodating, both I think on both ends and with all the parties, because now we have we have 5 school districts technically, and then we have 3 municipal entities. One is a water authority, so I don't want, it's not a municipality. So as we filed they filed their answer. So anytime you file a complaint in the courts, the other side has an obligation to answer those allegations. And then part of that pleading that they do is they file what's called new matter. New matter is their defenses. And Monroeville filed their defenses. And I just want to outline in their defenses in the new matter, they pled that the MS4 fees, and that's what these stormwater management fees are, was fair and reasonable. And then they also pled that the MS4 fee is required to be assessed, imposed, liened, and collected on a uniform basis based upon the area of impervious surface on each parcel. I then reply to the defenses, the new matter, and that's what I did on January, I believe, 23rd. And after looking at the ordinance and seeing what they did, I determined that their ordinance allowed for a 25% reduction for religious organizations that are exempt pursuant to 501c3 if they have 2 requirements. And one of the requirements says, if the property is used only for the conduct of religious services, and then it says or. So you don't need religious services. It just says, or religious education. And then the other caveat to it is no exempt activities are conducted on the property. So, or no non-exempt activities are conducted on the property. So when Monroeville pled that they apply this uniformly, it was my legal response, according to their ordinance, that you don't apply it uniformly. And not only do you not apply it uniformly, you don't do it with education. Because if a parochial school or a religious school is operating on a Tuesday and teaching math and science and social studies and literacy and facts class and whatever else that kids are learning across the street or at Gateway, but they also get a religious class, does that school get the 25% reduction? This issue was just a collateral issue that I raised because they said it was uniform. It is, to me, legally is not uniform, and I felt it was our legal obligation to respond that way. As a result of our pleading, I believe Monroeville has now amended their ordinance to eliminate that provision with respect to the 25% discount. And what they did was they adopted the ordinance so that it's effective from 2021 moving forward. And I believe that the section that they eliminated is still in play because we paid in 2019. I'm not sure if Paul can answer better if we paid in 2020 or not. But because the ordinance language was in effect at the time of 19 and 20, I believe it's still an issue for the courts. So I've not removed anything from our litigation or anything like that. I would recommend to keep it in there, and maybe we can use it for settlement purposes in the future, but I wouldn't recommend removing it now. And that is all I have.
So churches came into the discussion, basically, you're saying because you had to refute their statement that the fees were applied uniformly because clearly they weren't, and you read directly from their ordinance.
Correct.
Okay, and then, so we were asked to remove the church from the lawsuit. You touched on that a little bit.
I believe there was a
recommendation-
request.
There was a request for us to remove that, yes. And what was your legal opinion on why we should or should not remove that?
I would never recommend to a client to remove an issue unless there's something more on the table towards settlement. And there was nothing other than please remove this. And I understand, as a lawyer, and putting my lawyer hat on and representing the taxpayers, and this is what we have to do, I would not recommend removing it. Now, again, it can be for something for settlement, but I would not recommend removing it.
Well, now, there's 5 other people involved in this lawsuit, so how does that play if we hypothetically said, okay, we'll try to remove it? What would be required?
So I believe that the AIU and Forbes Road would still have a claim. I don't know what Cornell School District and West Allegheny's ordinances state per se. I can't recall whether they have the discount. I don't believe so, but I don't want to misspeak. So I don't know if those two would have authority, if they have any fight in that game or in this issue.
The minimum would be 3 districts would have to agree.
Correct. Gateway, Forbes, and AIU.
They would have to agree also to remove it in order for that to actually happen.
Correct.
And whose best interest would that actually be in if that were to happen?
Well, I listened to the Monroeville's council meeting, and as Mr. Ratcher said on the council at the council meeting, it is in the Monroeville's best interest for their lawsuit to remove it. And so, yes, I think it would be in Monroeville's best interest, not Gateway or the other plaintiffs in the suit.
And who do you represent, Chelsea?
Gateway. I actually represent Forbes Road as well, and I did not recommend to Forbes to remove it. So.
Okay. And oh, I know what I wanted to ask you about the reason for the statute in the first place. We talked about this, you and I, previously about double taxation. And you felt that that was part of the reason the statute even exists. Can you just
Yeah,
explain that a little bit?
well, we're using the school district gets taxpayer funds to supplement their budget. Taxpayers are paying for all of you here, including myself. And now to implement a fee against the district to do this work, it's like a double taxation in my mind. I'm not going to say that's exactly what's happening, but now you're asking the taxpayer to pay their property tax to the school district, and now school district take those property tax dollars and put it back to the municipality. And now school, you have to come up with this extra $90,000 over here to fill your budget, or because you no longer had that money, you no longer have it in your budget. And I don't believe the legislature created the statute to to create a double taxation. They're going to try to eliminate that. Let's use the money as most efficiently and effectively as we can.
I just thought that was interesting insight, and I thought it was worthy to bring up, because the homeowner's paying the fee, and they're asking the school district to pay the fee, but we get the fee from the homeowners who are paying the
Who
fee.
are already paying the fee.
Okay.
And they're paying their school tax.
And they're paying their school tax. It's
Right,
like triple
so-
taxation in a way. All right, I'd like to open up the floor to any other board members who have questions for Chelsea or Bruce.
Chelsea, the council's recent decision to amend the ordinance, does that have any effect on our lawsuit moving forward?
Well, the collateral issue goes away from 2021 forward, moving forward. But for 2019 and 2020, I believe it's still an issue out there. I think ultimately I think the school code, the main issue though, is the one to focus on. This is, I think we have a great case, and I think ultimately we will win. And then if the municipality wants to implement a discount thereafter, they can do that. That's a way around it.
So is it your opinion that it's our fault that the churches in the community are being, what's the word? They're being charged now the discount that was initially given to them for the first 2 years?
It is not Gateway School District implementing the MS4 fees. So we are not charging the taxpayer this money. So it is Monroeville who chose to charge churches, charge schools, charge residents. And so whoever they wanted to put in their ordinance, it's on Monroeville. It's not Gateway. And so anybody getting any discount, that's on Monroeville, not Gateway. I don't know how else to say that.
Mrs. Delaney?
I just want to ask, we initially paid that 90,000, and that was for 11, were all the 11 parcels, are they all school properties? And did we not, when we paid it, we did not feel or know we were exempt or should have been exempt? Why did we even pay in the first place?
Because under the law, you need to pay it and go back and get it back from the judge. If you fail to pay it and we're wrong, then you'll have penalty and interest, just like a tax liability. Even though they're not calling it a tax, if you pay it late, you're gonna have a penalty and interest. So we pay it on time and then hopefully get the money back. They get to earn money off of it. I don't know what kind of account it's in, but if it was an interest-bearing account, then they're making money off of our money, and I'm hoping we get it back, but those years that we didn't have it, we didn't make money off of it.
And the second thing, I was just, Cornell School District and West Allegheny, why are they involved? They're not part of the program.
Correct, but these MS4 fees, so this started a long time ago. I can't remember when the DEP came down and said that these permits have to be issued, and this has been a long time coming. All municipalities that are collecting stormwater will be eventually coming through, and if they haven't done so already, they are doing it shortly. So everybody in the state of Pennsylvania is eventually going to get hit by this. I think what is happening are municipalities, they're waiting to see how to implement this better and see how Monroeville or other municipalities have already done it. And I know for a fact, because I've gotten calls from other school districts inquiring about the status of our litigation, because other school districts are waiting to see what happens in this litigation to see whether they jump in to their municipalities and say, hey, we're exempt.
In other words, if we are found exempt, it's a state code.
Well,
So it doesn't necessarily negate the result, it gives them a development.
it gives them precedent. So the Court of Common Pleas isn't the highest court in the state of Pennsylvania. It goes Court of Common Pleas. This would go to the Commonwealth Court and then to the Supreme Court. But it gives them a precedent to be able to rely upon because there isn't a decision with respect to specifically MS4 fees. There is a decision, a Supreme Court decision with respect to sewers, which I believe this still is the same thing as a sewer. Whether it's a sanitary sewer or a stormwater sewer, a sewer is a sewer is a sewer. So we don't have a decision again for stormwater fees or stormwater sewers.
Chelsea, there are a few other small religious educational organizations here in the Monroeville, Pitcairn area, and they're not on the lawsuit. But as Rick just said, they don't have to be on the lawsuit to be affected by the positive or negative outcome of the lawsuit that we are taking ownership of and leading, right?
Correct.
Does it apply to public school and private?
The school code will still apply to the private school, parochial schools, so they will get the benefit if we.
Voice campus.
Under the school code, I would have to check, but I would think that they would still fall under that provision of 776. Because it's boys campus, I'm wary of saying because it's collegiate, I'd have to check. Because I don't generally deal with that level. But my gut would say yes, it would still apply.
Thank you.
Mrs. Warren, say, being a part of Sunrise School, we're piggybacking off the Gateway. They were apprehensive of paying the storm sewer tax. Their budget is minimal compared to Gateway.
That's a
So-
fee, remember? It's a fee.
It's a fee.
Sorry.
It's a fee.
It's a fee.
But what I'm saying is they are anticipating, and every meeting we have, they ask, if we heard anything. So this would benefit, for them also. Just put that out there. Scotty, I think Forbes too, you're having the same issue.
Do you have anything else? Does anyone else have any questions? Anyone on administration have any questions? I don't want to forget about you because I can't see you in the room. All right, seeing none, I just was going to read this little closing that board leadership put together. And if there's any other comments from board members when I'm done, feel free. If not, we will move on, or you can address them in your board reports again this evening. But to summarize our position, board leadership wrote the following statement. Ms. Dice gave an excellent presentation summarizing the background and reason for the lawsuit. It is the opinion of the board and the district solicitor that Gateway is exempt from the fee as per the Pennsylvania School Code, which is still up on the screen for those viewing from home. Other schools, as she explained, have interpleaded into the lawsuit as additional plaintiffs. A secondary point, not the primary argument, is that the ordinance created by Monroeville only exempted some, not all nonprofits, including schools, based solely on being a religious entity. This is discriminatory in nature. This point was added to the lawsuit in response to the municipality making the argument in their own rebuttal that the fee assessed is applied evenly and equally to all properties. The reality, as she explained, is that that is not the case. The district is not taking the stance that any such religious entity should not receive a discount on the fee. We believe the wording in the municipal ordinance excludes the district from such a discount in a manner that is inconsistent with state law. Yes, I did receive a call asking for us to remove the portion of the suit that mentions churches, but all other plaintiffs in this lawsuit would have had to agree to do so. And that decision may even require court approval. if there was simply not enough time to follow up for all of that to happen before council made this decision last Tuesday to remove the discount from the ordinance. Even if the district were given enough time to remove the wording from the lawsuit in question, it would have done so against the advice of our solicitor, which you heard this evening. Pointing out the discriminatory nature of their ordinance only further strengthens our case. The school board is not of the opinion that religious entities should be denied the discount created in the ordinance. We simply want to see the discriminatory language removed, thus extending the discount to all schools, including Gateway. My personal suggestions to the mayor were as follows. 1, rewrite the ordinance and include all tax-exempt properties in the discount. Or 2, settle the lawsuit with us, and the additional language regarding churches would no longer be an issue, correct?
Correct.
Sadly, they refused both. The attack on the taxpayers and the religious institutions in this community are coming from the council and the council alone, and they are now trying to use the Gateway School District as the scapegoat for this poorly planned and illegally written ordinance. The fact that they said we would not work with them and their hands are tied is simply untrue. Council had several options available to deal with the mistake it made when drafting the ordinance. If the wording in question was legal, there would have been no reason to remove it in order to help the municipality in the lawsuit. The reality here is that it did hurt their case because it was discriminatory, and that is why they voted to remove it. Instead of simply recognizing the mistakes made in drafting this ordinance and correcting them, council has decided to take a case they have little chance of winning to court as they attempt to defend the illegal assessment, further burdening the taxpayers in Monroeville and Pitcairn with legal fees and other costs associated with the court process. The mayor and council chose to pressure the school board to remove the wording. If we had agreed to do so, it would have meant we were taking action against the best interests of the Gateway School District in order to strengthen the municipality's case against the district. Council described our lawsuit as a, quote, disaster for the district. The true disaster is that the municipality imposed an illegal fee on the Gateway School District, i.e. and the taxpayers, while acting in a discriminatory manner against the district, and then they have the gall to blame the district for calling them out on it. This board is committed to protecting the taxpayers, and it's high time Monroeville Council show the same commitment. With that, I would like to open it up to any of my colleagues for additional comments. Okay.
Thank you. That's what I wanted to ask.
Thank you.
a good
Okay.
Well said, Mary Beth. I think it's a shame that we have to even have these conversations back and forth the way we are. I think we can all just be professionals and handle this thing the way we're supposed to.
Well said, sir. Well, if anyone wants to comment on their board reports, feel free to. We'll just move along, and I don't have any comments.